Council may proceed. Is anyone making argument? Oh, it's all right. We're ready to hear this case and hear oral arguments. Yes.
May it please the court, Blake Hudson on behalf of Sedan City Hospital and also David Short. It was our petition for review that was granted. I would, Your Honor, request 2 minutes for rebuttal.
2 minutes is granted.
Thank you. This is a 12105B notice of claim to municipality case, and in this instance there was clearly no strict compliance, and in fact there was no real discernible attempt to comply with the statute. So the question is, was there substantial compliance? And certainly we do not believe there was. First, the notice was not served on the clerk or the governing body of the municipality. The first letter
Who is the clerk of the municipality in this case?
I beg your pardon?
Who is the clerk of the municipality?
There is none, Your Honor.
There is none. So who is service effectively provided to?
The amicus brief pointed out there is a case that indicates that service on the city clerk would have sufficed in this case as the parent of the hospital. That's Smith versus Kennedy, as I recall, in which the administrator of a county hospital was served along with the county clerk. There wasn't a clerk of the governing body of the hospital. And that service was given the vote of approval by this court. And so applying that kind of a rationale, then the city clerk could have been served here, or the governing body of the city, or the governing body of the hospital. But none of those people were served. The first letter, dated February 21st, 2010, was addressed to the hospital administrator. And from the holding of Myers versus Board of Jackson County Commissioners, we know this service is on someone other than the clerk or the governing body and violates the clear language of 12105B.
Well, the language isn't all that clear when you just went through, well, it could be this or it could be that, or it could be the city clerk, or it could be the city commission, or it could be the board of trustees of the hospital. There is a built-in ambiguity to the actual language of the 12105B.
Well, there could be, according to Smith versus Kennedy, but we're still talking about a clerk or a governing body when we're talking about the governing body of a city or the governing body of the hospital or a clerk. I don't think it's as broad as the plaintiffs would like to take the view in this case, and that would include an administrator. The statute very clearly says clerk or the governing body. And it could also just as easily have said clerk, manager, or administrator, or the governing body. But it doesn't include administrator or manager. And because it doesn't, we think those are clearly excluded. Now, we hope clearly excluded after the decision in this case anyway. The administrator or manager is simply not the clerk or the governing body of the municipality. He is or she is not. The second letter.
Counsel, before you move on to the second letter, I want to ask you about the first one for a little bit. The first thing is, am I correct that the record on appeal does not go into either the contractual arrangement with the hospital administrator with the hospital, or into the deposition of facts, or just what constitutes the authority of the hospital manager?
Yeah, there was no discovery conducted on that. Our motion for summary judgment or dismissal was filed before any discovery was started or completed.
Why wouldn't it be possible to do discovery on the hospital administrator's authority in order to see whether that authority is similar to that of a school board superintendent, where the law has said that providing that notice to the superintendent is good enough?
Well, we simply don't think it's required, but, you know, obviously that is an option that's available to this court to direct. But, you know, administrator is a manager. I mean, that's what it's defined as. And, you know, the superintendent, first of all, I think that was really a questionable decision. It was a decision that was a number of years ago, and it was before Myers versus Board of the Jackson County Commissioners. But that was the superintendent, and I think the reasoning in that case was that the superintendent is essentially in charge, as the governing body is in charge, or at least an arm of the people in charge, and that's how that was rationalized.
And maybe, as Justice Biles points out, that needs to be developed, because I would think that the CEO of a hospital is in charge of that hospital.
But the CEO was not served. It was the administrator that was served in this case.
Hospital administrator, the head administrator was served, isn't that right?
That's right. It would be it's the person who manages the hospital on behalf of the Board of Trustees.
And isn't that person involved in, and again, we don't have the discovery on that, but isn't that person involved in the day-to-day operations of the hospital? It's not the governing board comes every day to the hospital to supervise the hospital. It's that person who's delegated to do that.
Well, that's correct. She has the day-to-day management, but she is not the governing body, not a member of the governing body, and she's not a clerk. And so I simply still believe and take the position that serving administrator is akin to serving a city manager in a city, and that's just not proper under the statute. You serve the clerk or the governing body. And there's a whole board of trustees available to be served in this case too. If somebody really wanted to comply with the statute, literally, certainly there's nothing to stop that from occurring here.
Let me ask you about the contents of the first letter. Looks to me like there are two defects under the statute. The first one has to do with the address of the claimants. Is there any reason to believe that under these facts, because you'd have to separate it out and say, looking at the letter as a whole, is there any reason to believe that leaving off the address of the claimants in any way hinders the hospital's ability to conduct a full investigation and review the merits of the claim?
No, I do not. I think that's immaterial.
Let me ask you then, the other thing that's missing from the first letter is a statement of damages. Would you see there's a difference between damages and the address of the claimants?
I think there's a big difference.
What is that?
A large difference. Well, because in my view, you don't even have a claim until you've made a demand for some money to get paid for something, get paid something, and that's what makes it a claim. That first letter made no demand. It did not seek any money. It talked about a wrongful death claim to be filed, and then it suggested that the hospital might want to settle, but it contained no figure. And I don't know how a municipality can evaluate a claim if it doesn't know what the claim is.
Well, you know, the Court of Appeals opinion is interesting because there were three judges on the panel, and each judge had a different opinion.
Yes.
Then Chief Judge Greene said that you really had enough information on the claim because of the statutory caps that would be in place. And so I read that to be there would have been a wrongful death cap and then a cap on pain and suffering, because if I understand the facts, the deceased lived for a while, so there at least might be a claim there. So you've got these caps in place, and you know, why isn't that good enough to know in the ballpark of basically the significance of the claim you've got in front of you?
Well, I think there's several problems with that come to mind. One of them is, of course, that is a cap. It's a $250,000 cap, and as of course you're well aware, Your Honor, in both the medical malpractice claims were the wrongful death claims, and in all personal injury claims also. Two different statutes come to the same cap. But not everybody sues for the maximum. not about every claims, especially if you're trying to settle the case. If you make a demand, you're not bound by that demand necessarily. According to a recent case here, when you later file suit if you have to. But still, not all claims are going to include the maximum non-pecuniary damages claim. And there's also, of course, another element, and in this case, probably a much larger element, and that would be the pecuniary loss. And the letter didn't mention anything about a pecuniary loss either, or non-pecuniary loss as far as damages figure. And Judge Green's analysis did not address non-pecuniary loss whatsoever. He mentioned a $250,000 cap, and basically said we should assume that they were going to include that in their claim. But the itemized claim that came in on May 2nd was for $1,183,000. Now, I don't know how you could get $1,183,000 as a claim out of anything that was contained in that first letter. And I think that that's a big flaw in Judge Green's reasoning.
Let me ask you about the second letter then. Let's move on to it, where damages were mentioned. Assuming everything else is complied with, what's wrong with a municipality delegating to a third party the responsibility for receiving all of the information required by the statute and then being able to do a full and complete investigation of the claim prior to suit?
I don't know if there's anything really wrong with that. I don't know if the statute actually contemplates that being done.
Doesn't prohibit it.
And it doesn't seem to prohibit it. It just says clerk or the governing body is who is supposed to receive the service.
And why can't they,
And I think you could appoint-
can't they delegate their receipt of that information to a third party?
Well, they may be able to. They may be able to, but
In fact, they have to. If they're insured, and the municipality negotiates a settlement without having the insurance involved, then they've negated their insurance. So the insurance company has to negotiate the settlement.
that's true. And they are an agent and a representative for purposes of resolving the insurance claim. But they have never been appointed as an agent for service of the notice of claim. I think there's two different issues there.
Counsel, you're out of time. Would you like 30 seconds to wrap up?
Well, I got to my second page, Your Honor, so, no, I will save for rebuttal.
I do have one question I'd like
Yes.
to address before your opponent speaks, and that is the personal jurisdiction versus subject matter jurisdiction
Yes.
of the notice.
Well, I think that Judge Atchison was correct, and I don't think this court has ever specifically said whether 12105B is a matter of subject matter or personal jurisdiction. It has said it is jurisdictional. And, of course, the Court of Appeals, not Judge Atchison, but other panels have flatly said that 12105B involves subject matter jurisdiction. I believe it is subject matter jurisdiction. Judge Brazel, in his dissenting opinion in this case, discussed that, and I think he has a good analysis. He argues that 12105B is born out of governmental immunity, and that is the reasoning for it involving subject matter jurisdiction. I think that's a good argument. To me, the statute is a absolute condition precedent to filing suit, which means if you haven't complied with the statute, the court cannot entertain the suit, cannot entertain the subject matter of the suit. And so I think it is subject matter jurisdiction. It may be a little bit of both. I mean, notice generally is, I think generally concerned is personal jurisdiction.
In service?
But on the other hand, the Christopher Court said if you don't comply, the suit is void ab initio. And that sounds something like subject matter jurisdiction to me, and so I think maybe it's a little bit of both.
Any more questions? Thank you, counsel.
Okay.
May it please the court, Tom Harris for the appellants. This is basically a substantial compliance case, and I have cited on page 10 of my brief the cases regarding substantial compliance, which I believe there was clearly a substantial compliance in this case. Since I wrote that brief, there was another case, Continental Western Insurance Company versus Schult, decided on July 5th of this year, that also indicates substantial compliance is compliance with provisions and requirements is sufficient. Substantial compliance means providing the essential matters necessary to ensure every reasonable statutory objective is met.
So what's the statutory objective to designating that notice be given to the clerk or governing body?
Well, in this case, the hospital had no clerk, and
What is the reasonable objective of the statute, which is what we have to look at to consider substantial compliance?
I believe it's to give the hospital sufficient information regarding the nature of the injury, the time, the occurrence, and to allow them a chance to investigate thoroughly the matter. And I think that the...
And having said that, then the content provision that includes a statement of monetary damages claim, why isn't that an essential matter necessary to accomplish the reasonable objective of allowing investigation and consideration of the settlement?
Well, I think it is. However, as noticed by Justice Green and in some of the prior, perhaps, questions, the initial letter on February 21st of 2010 had all the elements necessary for the claim, with the exception of the monetary damages, but they were capped by law. I think
That's not true, counsel, because you obviously made a demand that's double what the statutory caps would have been, and I assume that that's based upon the fact that there's no cap on economic loss, and that that's what you were basing that on. So really, it's kind of a bait and switch deal. I mean, the hospital's supposed to believe it's got a $500,000 claim when instead it's got $1 million+ claim, or even more I mean, economic losses could go even higher, I suppose, depending on your deceased. So the caps can't really communicate very much, I guess, is my point.
Okay.
I want to ask you, when you wrote the first letter, did you even know this statute existed?
Your Honor, I'll admit that I did not pay attention to that statute. I typically give the same sort of information on personal injury claims. I would have...
It read more like a kind of a Nelson versus Miller kind of
yes,
thing.
But I think that the letter conveyed all of the information required by the statute.
Did you understand that the Sedan City Hospital was a municipality? Did you understand that?
We did a lot of investigation.
That you maybe didn't appreciate that?
Right. We tried to find out who owned Sedan City Hospital, and you know, since there's no clerk, if there's a board of trustee that runs it, they're essentially invisible. They're not required to register anywhere.
Why wouldn't the name give you a pretty good clue? I mean, we're talking about notice to municipalities, and the name of the defendant is the Sedan City Hospital.
Yeah. I don't know if that's so much of a clue of who really owns the hospital.
Why not?
Okay. Well, our investigation was that another hospital was a parent company to that initially, and it was hard trying to pin down exactly who owned the hospital, and I don't think that the name denoted that it was owned by the city of Sedan.
Let me ask you to address another problem I'm having, which is the comments from Judge Atchison on the waivability of the 120-day filing rule. It seems to me that if we agree with that, we basically are saying that the statute's 120-day period for investigations of municipalities no longer exists, because the plaintiff's bar can simply file lawsuits and just see whether the municipality waives it, and if they do, fine. If they don't, then we've got a lawsuit. Now it has to be, it has been prematurely filed, it has to be dismissed, and then we have to go back and do that. It seems to me we've got to be fairly strict with the 120-day rule, or else we create problems that the statute's designed to prevent. Don't you agree with that?
Well, Your Honor, on the issue of whether or not the petition was filed prematurely or not, and what that effect would be, in the event that the February 21st letter was substantially complied, then the 120 days would have applied, and it would not have been a premature filing. In the event that substantial compliance didn't occur until May 2nd, where the itemized damages were provided, in that case, it would have been prematurely filed, should have been filed after August 30th instead of August 2nd. During that 4-week window, it could have been dismissed, but it wasn't. And therefore, I believe a premature filing would simply lay
Service of the notice of claim on somebody other than the clerk or the governing body. I mean, I can't get around that. That's there. But on the other hand, I think this case fits those cases which said service on somebody other than the clerk or the governing body was inappropriate. But we're not claiming prejudice. I don't think you have to establish prejudice under 12105B. And I would point out that, you know, in Myers' case, there was no question there was actual notice. The claim had been fully investigated by the insurance carrier. There was no prejudice there either, but the notice just wasn't served properly.
Do we have any further questions? Thank you, counsel.
All right, thank you.
We thank you both for your arguments this morning. The court will take this matter under advisement. This time, the court is in recess for 15 minutes.